took ownership of, he made a mistake, and he, acknowledged that to me.
And I don't know if were you here earlier for the testimony from the doctors and some of the other stuff?
I was.
Okay. Did you know that Mr. Phillips was doing any of those things?
When we met later that week, he did let me know that he was beginning some behavioral therapy.
Has he been compliant since then with you?
Yes, since the incident, he has been in compliance as far as his other conditions of probation.
And I know you had originally made a recommendation of putting him back on probation. Do you think that he would be amenable to community-based sanctions like house arrest, community control, things like that, curfews, behavioral things, or kind of control short of incarceration?
Can you repeat the first part of that question?
Yeah. Do you think that either house arrest or community control or even a curfew would be something that would be a good idea in his case if he goes back on probation?
Yeah, I think he definitely has the capability to abide by the conditions of his probation.
So you would be okay with the recommendation you made originally, which was a curfew for 6 months? Would you be okay with even house arrest or community control for a year or 2 years as a kind of a punishment for what happened and give him a chance to complete his probation?
Yeah, probation would be okay with the community control sentence. My original recommendation for curfew was really just based on the police report, assuming that he had one beer. Based on seeing the video footage, it appeared that he was intoxicated, so we would have probably recommended something a little more severe than just a curfew.
Okay. Do you think community control, would that be adequate?
That would be a fair recommendation from Department of Corrections.
And what I was going to propose was something along the lines of, weekly AA, NA, or drug counseling. Continue to see your therapist weekly and continue to see your psychiatrist, take all medication as prescribed. Would those be reasonable conditions, do you think, if Mr. Phillips was placed back on that type of probation?
Can you repeat that again? I'm sorry.
Yeah. What if we added something like continue to see your counselor weekly, continue to go to drug and alcohol classes, maybe get another substance abuse evaluation if that's necessary, and continue to see the psychiatrist and take the medication he prescribed? Would those be good amendments to his conditions of probation?
Yeah, I think those would be good modifications.
Do you think he needs has he already had a substance abuse evaluation, or should we get a new one?
He has had a substance abuse evaluation. It was right when he first got put on, so it's been a couple of years since then, so I would recommend another one, just for one of our vendors.
Sure. Thank you. I don't know.
Very good, Judge. Officer, you gave your recommendation for the curfew on 9/21/2021, right?
Correct.
You gave your violation report over to the court.
Correct.
And you didn't even ask for a warrant at that time, right?
I did not. He had already had a court date,
Okay.
so I just stuck with that.
And your reasoning for not issuing a warrant, not giving any further recommendation other than adding a curfew is based on the information that Mr. Phillips had provided you via email, right?
Yes, it was, and at that time, I had also read the police report. So based on Mr. Phillips's information to me, as well as the police report, that's where my recommendation came from.
Okay.
From a procedural standpoint, he was already arrested for the VOP.
I'm about to address that,
He
Judge.
had been arrested twice if he's not wrong.
Okay. Can I approach briefly? Just take a look at this and ask your question.
Okay.
This is pre-market statement for identification purposes, Judge. Oh, B.
He's already had vacation, right?
Do you recognize that?
Yes.
What is it?
It was the email that Mr. Phillips sent to me after the incident.
And it's a complete email, what you remember reviewing it, has it been redacted or
No.
changed in any way? Okay, Judge. We just asked him to put the evidence that states to.
The objection? Act like it states to.
And it's true that Mr. Phillips never told you he was actually arrested for a VOP, right?
I was not aware until I happened to view the clerk's side and saw that he had been arrested.
In the email he sent to you, he told you that law enforcement searched him in his truck and let him go.
Correct.
And that law enforcement just told him not to be back in that, just to leave the nightclub. That's what he told you.
Correct.
He didn't tell you that an arrest was effectuated, that a VOP happened.
He did not tell me that he had been arrested. He did tell me that he did have a drink later when he came to meet with me in the office.
He didn't even tell you that law enforcement actually gave him a ride out, right?
Not until we met face to face and we talked about the situation.
Okay, that's all I have, Judge. Thank you.
Nothing for you.
All right, thank you very much. All right, so do you have any other witnesses?
No, Judge.
All right, just argument?
Yes.
All right, State, you go first.
Um,
Well, I guess it depends on, you're going to be arguing now on a partial basis.
I thought we kind of already addressed that.
Well, we did, but I mean, whether I apply or not, I guess is the issue too. But usually if I let Ms. Thomas go first, and if she wanted to talk about it, and if you talk about downward departures, then I give her a chance to, or you go first and I'll go second.
I'm happy to go first.
Let's do that.
First, as far as the downward departure, I know we established before we started this, that, you know, there is a factual basis for you to downward depart if you choose to do so. You know, the case law is pretty clear that a probationer is kind of in the care and custody of the judge. The judge has wide range on sentencing to do pretty much anything they want. And here you have complete freedom by virtue of the fact that there is a grounds for downward departure, which is that substantial assistance was rendered. That was the reason for the sealing of the court file, and all of that other brouhaha that came because of that was all because of Mr. Phillips's agreement with law enforcement, which he completed prior to entering the plea. As far as, you know, what you have here today, Judge,
Now, as far as that goes, since you're talking about that, the reason for the ceiling and all that, usually when we have CIs, the way I usually see it is they don't get the deal until the work is in. The work was not in at the time that he took the deal and the case was sealed.
not all the work was in. There was ongoing investigations, and basically
But
what happens.
that was what was different about this case versus all the other CI cases we have.
And the co-defendants also had to plan. And one of the conditions is testify truthfully against your co-defendants.
Right.
So you don't necessarily want to signal to the co-defendants that, you know, that you're going to be a cooperating witness because that has safety implications. Here specifically, Judge, was because it was on the dark web. Each identity on the dark web has a certain amount of authenticity. It's like being a seller on eBay. The more reliable you are, the better. But because people are more computer savvy, there was a greater reasons for security. That was actually requested by, I believe the FBI requested that. So.
And I guess the potential risk and exposure to the CI is greater in that circumstance than if we just had a CI working some buy deals.
Correct.
Around the corner.
Right. And typically in a case like that, when the CI is being run by like local handlers, there's much more hands-on protection, and the people that are arrested are then in local custody. This might have been a case out of California or Nevada with people, you know, associates known and unknown throughout the country. So it was just a different critter altogether.
Right. This wasn't our run-of-the-mill
No,
CI
sir.
case.
No, sir, absolutely not. Absolutely not. And that's reflected not just, you know, I mean, the elephant in the room is that there was a series of newspaper articles right before the hearing in this case, which I thought was somewhat inflammatory and made it difficult for us to try to resolve this case. But the reality is that even the co-defendant in this case the female co-defendant got 5 years probation. I think she's violated probation by leaving treatment. I don't know if that case has been resolved. I think it may not have been yet. But it wasn't like Mr. Phillips got 15 years probation, forfeited hundreds of thousands of dollars worth of assets that were seized, did drug treatment. There was a lot of other things going on. So, you know, and I don't know those other people, whether they were required to testify. I don't know what was going on with their cases. But this was a very atypical situation. as far as what his substantial assistance was, but not an unheard upon result. And like I said, the co-defendants got similar results. One person was deported to his home country, not ever being prosecuted, and the other person got, I think, 5 years of probation. Not that that's relevant to Mr. Phillips, but just for the audience, I suppose. There was nothing untoward or improper about sealing that record. The statewide prosecutor does that all the time in local cases when they're working with big drug cases or wiretaps. Because if someone gets arrested on a minor offense, it could reveal the wire and jeopardize it. They'll either seal it or hold off on arresting the person. So, but you know, that kind of reared its head today because we have this medical testimony, these medical records that I believe would have been filed under seal because they relate to treatment for substance abuse issues. But rather than do that, we just put it all out there to save the effort of people having to try to file motions to unseal. But what happened, Judge, is that Mr. Phillips, I mean, he is a young man, chronologically young, but maturity-wise even younger than his chronological years support. And that was part of the purpose of me presenting you with the letters from his therapist, the letter from his doctor, and then ultimately the testimony of his psychiatrist. He also had an undiagnosed mental health condition that kind of manifests itself at the exact age that we find himself here. And his violation of probation was stupid. It was very trivial. You brought up the driving while license suspended issue, and although that was resolved as I think a technical violation or something like that, that was another situation where he paid the ticket but didn't do something to get it reinstated, didn't really process it, didn't really know. Then when he got pulled over, he fixed the problem. So I mean, his violations have been based on immaturity and lack of.
That's not here today.
I understand, but
I asked the question because I wanted to see what your response was.
okay, I understood. Well, even this violation here today, Judge, is it's a violation of his probation. There's no question he's not supposed to be drinking alcohol. I think that his email, I don't know what the state's questions were directed, whether he was somehow minimizing it, or the fact of the matter is he notified his probation officer that he had contact with law enforcement, went in and was truthful with him. I think the week after it happened, he met with him, and has been cooperative and forthcoming in trying to resolve these things. I mean, I think that it's very hard to put ourselves in the shoes of someone who has an undiagnosed mental health condition and kind of expect them to behave as someone whose brain is not different. And now I think that Colton's getting the medical treatment that he needs, and he's getting some of the tools that he needs, kind of that are social tools as well as medical tools. He's in a different position to be held accountable going forward. And so what I'm asking.
You would, if I remember correctly, when the plea was initially taken, you had raised that issue too, or at least you let the court know that issue is there, correct?
Yes, sir. And not to embarrass him, but since kindergarten, he's been diagnosed with severe learning difficulties, processing disorders, attention deficit disorders, and just lower function than many of his peers, which has held him back. He struggled to complete school. He had to have need tutors, and it's embarrassing, but yes, I brought that up because one of the concerns I had is his ability he has a processing disorder where he'll read something and not quite get it. So when he says, I wasn't sure if I've done something wrong, he's not necessarily being disingenuous. He's really just not getting it. I had a conversation with his counselor. She said he's a typical 25-year-old. At 25, I was a licensed attorney, had tried cases and was running a law firm. I'm sure you at 25 have done the same. And so I said, wait a minute, that's not my experience at 25, but that's not what we're here to evaluate. In his particular case, he's had a very rocky road with a lot of painful steps along the way educationally, and that's what
part of the negotiation when you had the agreement with the state initially?
I don't know what they saw those records. I don't know what role, how that factored in. I'd like to think they considered the whole milieu of what happened. But he, for example, he was very good golfer, but he couldn't handle the academics of being on the team, things like that. He just repeatedly struggled with that. It's embarrassing for me to bring up, but it's necessary that you understand that. That's why we hinted to it and kind of put up a flag in the very beginning that, yeah, he can read, but it takes him a long time to do it. He doesn't have great processing. He doesn't have great recall. And I think probation has been very flexible with him. And when I talked to the probation officer originally, it was like, hey, I'm going to re-admonish him. I'm going to kind of go over this with him. mean, I think you can see that he's trying. The whole purpose, the way we constructed this was, I wanted to come in here and show you, look, Judge, we didn't know what we were going to find when we sent it to the psychiatrist. We just knew something wasn't fine. Now we have a diagnosis we can work with and a medical plan, and that's not something that that's not something he can malinger, and that's truly like, hey, there's something going on here. But he's got, the grief with his death of his uncle, he's got all these other issues, the stress of life, probation, whatever. We got him talking to someone on a weekly basis that he can interact with, who can help him with that. He's seeing his GP as well, who can kind of look at all that. His psychiatrist is aware of the counselor and the GP. And then we went and had him go to a drug and alcohol, 12-step type meeting. We picked one that kind of auto-validates, because I thought that would be a good way of showing everyone. This isn't just like he didn't show up for 20 minutes and drink some coffee and leave. He was there, it's automated, and he could continue to do that. So when I saw that probation was recommending a curfew, I knew that wasn't going to satisfy the state. And when we were here at arraignment, I tried to get something done. You were talking about kind of a wake-up call, and I thought, well, if we put him on house arrest or community control, and we give the medication a chance to kick in, and we give him a chance to work and pay off the fines, he just paid $1,000, I think, was his cost of probation. He's been making big payments, but he owes like tens of thousands of dollars. Let him continue to do those things. Let him, let the medication kick in, let the counseling, all these things work, and give him a chance to kind of appreciate, A, the consequences of what he's done, but not, put him in jail or prison and say, okay, boom, that's it, there's not going to be a second chance. I mean, I understand he got a very good result the first time around, but, in an individualized basis, he's not the same as other people that come in front of you. And maybe with the medication, he can grasp it better. No amount of medication is going to make up for the cognitive issues. That's always going to be an issue there. And again, that's why we brought that up last time. It's just, it's always going to be there. And I understand the court's hesitancy in having sidebar conferences, things like that. Those are all very standard. We do them in all the cases, but I understand their hesitancy here because there's been a suggestion that somehow he's getting a better deal or a different deal. I think truthfully, he's being scrutinized more on the violation of probation than another person would be because of that. I don't think that, we have someone who clearly has a mental health issue, who's clearly amenable to treatment, who's self-reported to probation, who's been proactive with at least weekly events, therapy and treatment weekly, plus a counselor. I mean, it's not, that's not maybe not a Herculean effort, but it's pretty good for a kid who doesn't have all the same processes that maybe the average person does. I think he's doing the best he can to make up for it, and it's a wake-up call for him. I asked Dr. Ali, I said, people recoil at that diagnosis, and people do. They don't want to be told that they've got some condition. They don't want to be told you're bipolar, that has a stigma to it. But the good side, which I talked to Colton about, is when you find out you have something, now we can treat it. So yes, there's a stigma, but he's amenable to that treatment because even he admits, although he couldn't put his finger on it, there was something wrong. Something was getting worse, and that's what Dr. Ali said. There's a possibility that things were getting worse, and that's why we saw this escalating thing. But it's the lack of attention to detail, the lack of processing, the lack of cognitive, the ability to connect consequence to cause and effect, or just to be what we call responsible. That's why I mentioned the driving, because that's the same kind of thing. And I think Colton's been honest with you when he answered you. I don't think Colton's dishonest or trying to hide the consequences of what he's doing. I just think that he needs extra attention and extra kind of hand-holding to make sure that he can do some of these things. And that's why I'm asking you to give him another chance, Judge, to put him on community control for 2 years. Let him go see his therapist on a monthly basis or as recommended, to be compliant with all medical treatment required, to get a new substance abuse evaluation and follow that recommendation, to attend at least weekly some sort of drug or alcohol-based treatment program like an AA, NA, or Smart Recovery, and to continue to see his therapist on an at least weekly basis until the therapist recommends a different change. If you want to call it get a mental health evaluation following recommended treatment, that's fine too. If the state wants a different provider, that's fine too, but these are relationships that he's building in the community. At the very least, Judge, I would just add, give him a little bit more time under Dr. Ali's treatment for the medication to kick in and and let's see if we don't have a different young man. Hopefully you never see him again, but let's hope that passage of time and the medication gives you a different kid. That's what everyone's here hoping for. You can see on the right-hand side, or your left-hand side, the courtroom's packed with his family members who are here because they too want to see a different kid. I mean, no parent wants their kid to be punished. Of course, we all get that. But no parent wants their kid to have an undiagnosed condition that they can't help. No parent wants to feel helpless, and that's where we've been. So I know that this is not the realm that we bring these things to light in, but we are thankful that at least we have a diagnosis and something to work with. So please, Judge, we're asking for some mercy and another chance for Colton. Please give him a chance, put it back on supervision, community control, with at least the conditions I've asked, or any other conditions you think are necessary. If you want an ankle monitor, if you want a scram monitor for alcohol, any of those conditions, Judge, we would agree to. But to put him in prison or jail at this point, especially if you started a new medication, we hope that's not what you're considering doing, Judge. Okay.
The score sheet, did you have any objection to it?
It was correct. It was the same score sheet we saw last time with the 6 points for the violation act.
Same priors.
Yes,
All right.
I just added the 6 violation points, Judge.
All right.
That's what I thought they did. They just pulled up the last one, right?
Yeah.
The felonies on there, was that as a juvenile or as an adult?
It would have been a juvenile, but let me double
Which
check.
one, Judge?
Resisting with and bad Leo. Is that as a juvenile or an adult?
Are you talking about I think they say misdemeanor, Judge. Or maybe I'm
It's on the score sheet. Want to look at it?
sorry. I have a 3-page.
I see the score sheet.
Yeah, mine says 3 pages.
It'll be on the front page of the prior record.
Mine said trespass, resisting without possession of alcohol.
Possession of alcohol. Let me see what we have. Yeah, that's the one with the check report. And I have this one back where you are. Yeah. That's the one that I gave to Novado, he's reviewed with his client, Judge.
So he doesn't have any prior felonies.
No, Judge, the stuff that was referenced was juvenile stuff, but the 3 scorable things on the score sheet are misdemeanors.
All right. Okay. All right, go ahead.
All right, Judge, so from the beginning, we've spoken to Mr. Novado. The state's position is that there needs to be an adjudication, and we were just looking for a term of incarceration. I think, if anything, the reason that the scrutiny comes with the probation is simply because of the plea that he got on the front end. He got a really good deal for providing substantial assistance to law enforcement. That was considered, that was been over with him in court and reviewing the digital recordings. He was warned every single way possible by not only Mr. Delgado, but also the court, that if he violates, his exposure is tremendous. It's 151 years potential jurisdiction on 4 first-degree felonies, 3 third-degree felonies, a second-degree felony, and a misdemeanor, not including the violation points. Also, as indicated earlier by the court, he scores around 15 years, 15.8 years. I do think that the testimony today, while he was truthful about the Willis, he was also given a break on the Willis. He got dismissed based on paying the fine. That probation violation went away. So this isn't technically his first violation. The court does have knowledge of.
I don't think we got a report for it. I just want to make sure the record is clear that I'm not.
No, I know, I have one. I'm just saying that you asked about it, so I wanted to
Make
clarify.
sure the record's clear that that's not part of the.
Yes, Judge. You asked about it, so I just wanted to clarify. So today, for the 2 probation conditions that he's violated, is being in the bar, which he did admit. He admitted it on the acts on the officer when I asked him here about it in court. He's still not being forthcoming about the intoxication. I think his words when he testified was that he wasn't clear, he couldn't wrap his mind around exactly if he was supposed to not just be drinking to excess. I think the record's clear that it's just completely unambiguous in any form. The probation officer read the exact language and it says entirely. He's even told he's not supposed to be around people drinking alcohol. So we just want the court to take notice of that. We understand that he's been truthful about everything else. However, it just goes back to, it's not trivial due to the consequences that he was put on notice as to what would happen if he were here in the future, and now here we are. So we think that an adjudication is completely appropriate. We think that incarceration would, a lack of a better way to put it, be a wake-up call for what he could potentially be exposed to in the future if the court at one point decides not to extend that downward departure for his assistance. Thank you, Judge.
All right, so, recommendation is some incarceration, which you're not objecting to a reinstatement.
Wait, I'm sorry?
You're not objecting to a reinstatement as
No.
long as there's some incarceration?
No, actually, whatever the court decides to do, we want him placed back on probation and to have to complete the exact conditions and terms that he signed up for to begin with, Judge.
Okay. All right, I'm going to take a 1-minute recess. I'll be back.